Welcome back to Meet Up Speak Up. So, I'm about to let you listen to another audio, and the audio is consists of the actual videotape after the sentencing. When I realized that I was pled guilty and all the answers that I was asked to answer at a sentencing was basically entrapping me to the point of um, making sure that I was looked at and found guilty on something that I hadn't pled guilty on. So I hired another attorney, and we went after the guilty plea as well as the arms, which is the CPL gun. So in this video, you will hear the attorney argue about the plea and the gun, and this whole hearing was about the Gingrich law, which is an ineffective attorney. The attorney that I stated that pled me guilty without me knowing it. So this is what the hearing is about. But you will also hear the prosecutor continues to say, we're not taking back the plea. She pled guilty, we're not taking back the plea. Which I really truly going over the proceedings of the court. She could say whatever she wanted to say, but it wasn't up to her. It was up to her to prove whether I was guilty or not. She didn't want to prove that. She the one, I believe, orchestrated this whole entire thing because she made a statement to my first attorney, Harris, and she stated to him she didn't like how I spoke to the judge on the day I was first incarcerated. You will also get a audio of that judge too, and that is the very first judge that I was the first day I was incarcerated. But this audio tape is about after the hearing of the sentencing and me trying to take back the plea because of the attorney who pled me guilty. And I'm sitting up here saying yes to things that I never seen. And the only thing that the attorney had showed me was the drop charges document. So you would hear this attorney argue that, and he would argue certain statutes under the Michigan Compel law, which basically, like he said, if a person is in this predicament where it's an OWI, it is up to the police department just to send documentations to the board. And the board have to make the decision whether they're going to suspend the gun or not. You got to do a hearing in front of the board, and the board make that determination. Also, this case was still proceeding, meaning this case was still active. No guilty charges was of my factor. No guilty charges was actually stated for me. Even in the sentence tape, you don't hear me state I pled guilty under these charges. You do not hear that. You hear me saying yes to documents that I was assuming was charges being dropped or things that my lawyer had taken care of. You do not hear me state, yes, I'm pleading guilty. Yes, I'm pleading guilty. If you can hear that anywhere on these audios, please point it out to me because I never pled guilty. Anyway, you also will hear the judge say that she had a testimony where she pled guilty. I will show you all of these videotapes eventually, but right now, audio, I will let you hear them. There's no way on none of the videotapes I ever pled guilty. Matter of fact, I pled not guilty. He also say that I didn't have any legal basis to say that the gun was in the trunk of my car. Well, from day one, October 15th of 2015, 12, I stated on record that the gun was locked in a briefcase in the back of the trunk of my car. The officer report, where I will show you the officer report, where it states where the officer received the gun from. Now we have a prosecutor who stated that because I signed a document, which is a plea agreement she created from the lawyer, that the lawyer falsified and gave it back to her, stating that because she signed that, she gave him her rights to a gun. We all know that's not true. But, you know, we black and they think you're stupid, you know, naive and dumb. So that could be a factor. Also, he claimed that he read on a document that this testimony of a plea agreement occurred. I have been questioning for documents on this case for 8 years. And this past 2 weeks, administrator clerk of the court sent me a letter back stating that they had shredded all the documents. So, although I have no testimony, I have no reports, no analysis, no probation documents, no PSIR, which is reports for a probation. The only thing they have is a document that's supposed to be from forensics of the sheriff's department at a .15. And when I requested for them to send a specimen to another lab to test the blood, to see if it's my blood and what level it was at, they refused. And the probation officer had no report. Now, this is what the prosecutor said. The reason why she wouldn't send, which is a process of your due process rights, she would not send another lab where I would pay for it. I will pay for the next lab to analyze this blood. And the reason why she said she wouldn't do it is because I would take the blood tubes and throw them away. Now, forget your rights. Forget the due process of actually fighting a case. She refused to give it to another lab, a specimen, which you take a glass shield, you rub a little blood on there from the tubes, you let it dry, you put it in a sealed container, you put it in a claustrophobic envelope, and you ship it to the lab. But she wouldn't do that because I was going to take the tubes of blood. They had a 10-inch, supposed to be gray tubes of blood, and throw them away, destroy them. I said, ma'am, you're not sending the blood tubes to the lab. You're sending a specimen. A specimen is rubbed out on a little glass shield. Little of the blood is smeared across it. And you let it dry, and then you stick it in a cover. And then you put it in a bounded like envelope, and you send it to the lab. That's what you do. You don't have to send both of the tubes to the lab. She still denied my process of due process of analyzing the blood, because I already know it's not my blood. I know if I was drinking or not. I'm not as stupid, okay? But the whole point is to prove this case and plead me guilty so it won't go any further. And all the insinuations that this court judge made on record, whereas he was informed about different things that was going on. No, you was informed that I was going to put a complaint towards the police officer who did the sexual misconduct. I already had wrote him up as a judge. This is the judge who called me from downstairs and basically was like, I don't care, I'll put you in jail for 90 days. Shut up, do this, do that. So all the things that was coming to end is what they was trying to stop. And they got the right attorney to do it. So listen to the videotape and understand how retaliation can happen. This is all I can do basically, because I've been basically verbally trying to fight these people for 8 years. This is a very, very corrupt district court. Now, this is a district. Keep in mind, this is a district. We never got to circuit, to the state court. This is a district court. This is Meet Up, Speak Up. Keep listening. So, as you hear, the judge is basically arguing my case. He's a judge of the case. And he states that I was awarded numbers of consideration. Okay? I would like them documents. Okay? Because I am the client. So if I request for them type of documents of the considerations that he's talking about on the record, I should be able, because of a fair due process, I should be able to get them documents. I'm not. Why? It's because it's no considerations. I never gave anyone, attorney or nothing. The only consideration that he's talking about is he gave to me when he dropped all the charges. And then pretended like at the at the sentencing that I actually had confirmed all these documents. And I did not confirm anything but to drop in the charges document. So listen to this audio very well. He pretended that the 3K did not exist, which it does. Back that time in 2012, I haven't rechecked the law, but in 2012, you can have your CPL in a glove compartment long as it was locked, a trunk or briefcase, long as it was locked where, people couldn't get to it. And for him to say, I pled guilty on the record, and through all of these tapes, you will not hear me plead guilty. And for him to say that I pled guilty throughout the tapes, right? He said I'm pleading guilty throughout this hearing. But then he says, so basically, what? I don't know what she pled guilty for. I have no idea what claim and privileges was talked about. So how are you going to say on record that I pled guilty? Are you talking about the sentencing date? And I'm going to show you another tape where the charges were supposed to be dropped, and the date we supposed to came back to court on March the 12th of 2012 was supposed to be the date he accept the drop charges only. No other charges supposed to went through. And therefore, if new charges was going through, the court, the prosecutor, and attorney should have said, now, Your Honor, we are bringing her upon new charges. These new charges are, but you do not hear them say that. So if they was bringing me on new charges, which included my gun, and out through this tape you hear that I was not charged with my gun, you will also hear in the first appearance tape when I first was arrested on October the 15th of 2012, where it was no charges charging me for having my gun in the back lock briefcase in the trunk of my car. You will hear the bond where he states alcoholism because of the way I talk. Okay, this is the way I talk. Okay, I will say things that people may not, say as in my color race. But this is the way I talk. It is not an error. It is not an act I'm putting on. This is the way I talk. So, you will listen to many tapes. And as I get these tapes and organize them in a point where I can do audio, I will upload them to the YouTube site, Meetup Speak Up. So I just want people to understand what I went through and how long I've been trying to get justice out of a lie of a 43rd District Court. And you will also hear many more videotapes. So, this is Meetup Speak Up. Keep listening.